Good morning. So, apologies if you hear some feedback or me hitting this microphone. It's a bit unusual for all of us to use these. So first, thanks very much to the Government Accountability Project and the Food Integrity Campaign for having us. We're really thrilled to be here, and I'm thrilled to be leading this panel. My name's David Maraskin. I'm with Public Justice. We're an impact litigation organization here in DC, and I particularly work with our food project, where we focus on taking on consolidation in the animal agriculture industry, both through environmental lawsuits and consumer lawsuits and some constitutional challenges. And we're thrilled to kick this off, and the panel is really great. So sitting next to me is Paul Levy. Paul, if I did my math right, is it 42 years in December?
42 years on December 19th. Can
Yeah.
you all hear me without a mic?
Great.
Right,
So
so
Paul's going to put on his mic, and I will. Paul is with Public Citizen Litigation Group and has been there for 42 years as of December. Paul, as a 42-year career might suggest, has done a ton of different work, but is currently focused on free speech issues, particularly anonymous free speech on the internet, and is an expert in anti-SLAPP laws, which we will be discussing a bit more. But that's laws to combat what are known as strategic lawsuits against public participation. Next is Jason Zuckerman, who is with Zuckerman Law. As you might expect, he's a partner at Zuckerman Law. Jason has been recognized as, by Washingtonian Magazine as one of the most important whistleblower attorneys in the city on a regular basis. Particularly important for this panel, he is a former senior legal advisor for the U.S. Office of Special Counsel, which is where federal whistleblowers go when they have things to report, and he'll be talking about it more. Moving on down, Alexis Roniker is a partner with the law firm Katz Marshall Banks here in DC. She specializes in whistleblower and employment law. She's been recognized nationally for her work in employment law. She's one of 5 attorneys who were recognized by Law 360, which is one of our legal trade magazines, probably the biggest legal trade magazine, as a rising star in the nation. And certainly last but not least is Heidi Kitrosdorf. I'm stumbling over this even though I should not be. With the University of Minnesota Law School, she specializes in con law, federal secrecy, and separation of powers, and is working on a book on federal whistleblowers. So we're going to be talking about legal barriers to truth-telling, and it's a really both an interesting way to kick it off this panel and this conference, and also I think we'll be replicating a lot of the themes you'll be hearing throughout. Obviously, we live in an age where whistleblowers are under threat, right? We hear about unmasking of whistleblowers on a regular basis from the most powerful man in the country and the world. And there's a real attempt to silence, but what those of you who don't work in food on an everyday basis may not recognize is that threat has been ongoing and particularly severe in the food industry for years, and is only ramping up more and more as we have this administration take control. So just a couple of months ago, ICE raided Mississippi plants where slaughterhouse workers were working to check on their documented status. Something that might not be so surprising until you learn that those plant workers had just recently settled a lawsuit for sexual harassment against the company. It seems like direct retribution against these workers for trying to speak up and protect themselves, and then using the tools of government against them. And we're seeing that again by being used at the highest levels. Across the nation, we've also seen states enact what are known as ag-gag laws. These are laws specifically designed to penalize and criminalize the ability of people to go in and get documentary evidence about what's going on behind closed doors at agricultural facilities. They specify agricultural facilities in many instances. I'm proud to represent GAP in one of the constitutional challenges against these laws. But as you will hear, while these threats are out there, the law is finicky at best. The First Amendment has less meaning than we may like it to have. The law can be a double-edged sword, as we are going to hear from the panelists. And defending your rights means placing yourself at risk. Nonetheless, right, food whistleblowers, as you will hear throughout, have played an essential role in the safety of America, in the safety of our food system. From Upton Sinclair to now reporting against what you'll hear about in the last panel, the hemp program of moving pigs through slaughter lines so fast no one could possibly monitor them. Whistleblowers are essential. So what we're trying to answer is both, through this panel, both what are the real fears that people come to us with attorneys with, what are we trying to help people work through, and then what can the law can and can't do to help protect you. And so with that background, I'm going to kick it off really by turning to, I think Alexis is really the person to start this, because you have so much experience working with people on the ground who come to you and walk in the door, and you can really identify their experience of what it's like to try to come to you and report something, and expand on what Dr. Keene was saying. So I'll start with there.
Absolutely. So I get the pleasure of representing individuals who have blown the whistle or who are thinking about blowing the whistle and trying to figure out if it's the right choice, how to do so in the safest way possible. And I also actually represent frequently individuals who are suffering from sexual harassment, and it's awful. The feelings and what they're thinking through in these kind of cases are all very similar. And so if whistleblowers experience much of the same type of thoughts and concerns that have been discussed nationally around Me Too. And the first one is pretty straightforward. Most people in America can't afford to lose their job. And so, I really love when people reach out to us, and it's even before they've blown the whistle. Think through, how do you do this? Can you afford to do this? What's the right next step to position yourself? Because most people can't afford to miss the next paycheck. They can't afford to risk their health insurance for them and their family. They can't afford the long-term harm. For example, if you're, fired, you're looking for a job without a job, you're looking for a job with no reference from your most recent job. And in food in particular, I've had clients talk about what a small market it is and how the information gets out very quickly that they were the troublemaker. And so if they're in an area that's relatively small market for the work that they're doing, they're at best looking at uprooting their entire families and moving to, which again is very expensive. And so I think particularly for the folks that I've worked with who are thinking about blowing the whistle in the food industry, it's just a very tough question about, can they take on the personal drain in a real economic and emotional economic sense. But then they also fear hurting the people that they work with, because it can really affect the company just on a minor level. I often work at the clients I've had have been management level or executive level, which they're in better circumstances than the line workers and whatnot. But even for them, they're saying, okay, well, this is going to cost my company a lot of money, and I know Susie and John won't get bonuses, which they depend on, or even worse, the company really suffer, people could get laid off. So that's a concern that we wrestle with. And so those are the folks who are slightly better off. In vulnerable populations, David's already talked about the fact that folks with may not have immigration status, what are they going to be thinking about, all of these considerations. And then for folks in a vulnerable situation, will they be even believed? Will they take on all of this pain and suffering, and then they won't even be believed? So, that's what I've found on a personal level, folks going through, thinking through. And then if they even get through all of that and decide, yes, I still want to blow the whistle, or they raise the issues internally, and so they've been fired, and so they didn't even get the option of not being in this position. It's how do you do it safely? How do you logistically blow the whistle, given what we talked about? Ag laws, just contractual provisions designed to scare them out of raising these issues. And it's a lot to ask for a non-lawyer to even have a sense of what they can do. Is talking to the media safe? Is talking to the government safe? I have this contract, Jason's going to talk about this, that says, I have to give up all my documents and I can't share trade secrets. And I mean, you really have to have legal advice to figure out how to do it safely. And I work with managers and executives, and they certainly don't know. So then you talk again about vulnerable populations, and it's just a very scary problem.
Well, and Heidi, I know this is something that's also come up in your research, where It's not just about the legal concerns and the public concerns. There's actually like a physical set of barriers to whistleblowing and getting information. I was hoping you could kind of elaborate on that to lay the groundwork here.
Yeah, absolutely. So in a book that I'm working on about federal whistleblowers, I'm going to have a couple of chapters on USDA inspectors. And one thing that really struck me in looking at some of the stories and experiences of meat and poultry inspectors, I've focused especially on poultry inspectors, are the ways in which USDA has taken steps that essentially can nip whistleblowing in the bud before it even starts. That is, before you even get to the point where somebody blows the whistle and gets retaliated against. There are ways in which regulatory changes make it so difficult for inspectors even to see what's going on, literally physically, to see whether or not that's a problem. And when you think about it, if you're the USDA and you don't want to keep getting complaints from the big ag companies, even more effective than retaliation and all of the problems that come with that would be to make it so that whistleblowers are not really in a position to become whistleblowers in the first place. And so I was struck by how some of the changes to the processing lines and the evisceration lines in the plants, and this has been true across different types of meat and poultry, but again, I focused in my research mostly on poultry. So in the poultry context, I've been struck at how some of the changes in terms of increased line speeds, et cetera, have made it increasingly difficult for inspectors even to spot problems in the first place. And so let me give you a few examples. One of the things that I looked at were anonymous affidavits that GAP, and specifically Amanda through FIC, through this project that we're all here talking about today, anonymous affidavits by poultry inspectors that were compiled for a 2011 rulemaking that the USDA, Food Safety Inspection Service, FSIS, put together to essentially opine on the new poultry inspection system, which essentially is an offshoot of a pilot program, HIMP, the Hazard Analysis and Critical Control Point-Based Inspection Models Project, HIMP, right? And so these were inspectors who were opining on their experiences under HIMP in talking about whether or not it should be nationalized. And what struck me was how they spoke to the ways in which the changes in line speeds and other HIMP-related changes made it impossible for them even to see problems in the first place in many cases. And I know, of course, there'll be a line speeds panel later, but this is just a little preview of that by focusing on the way in which things like HIMP and similar changes can kind of stop whistleblowing before it starts. So one affidavit, for example, talked about the speed, the increased speed that was allowed under HIMP and that's now allowed under NPIS. And the whistleblower, the affiant said, quote, in a traditional plant, an inspector examines about 35 birds per minute. In the HIMP plant, where I am inspecting carcasses at the end of the slaughter line, in the carcass inspector position, I am expected to, quote, inspect, unquote, over 150 birds per minute. It just cannot be done. So again, that's, much more efficient way to stop whistleblowing. You don't even have to retaliate. You just make it essentially impossible for people to spot problems in the first place. Also saw similar comments about changes, greater flexibility that HIMP gave the plants in terms of the positions that the inspectors were placed in on the lines. So one affiant said, quote, the HIMP model is flexible enough that the plant can decide how much of the carcass they want the remaining inspectors to see, unquote. So again, and there were many, I think every affiant in the GAP submission spoke to this, spoke to the way in which the plants under HIMP were given more flexibility to sort of position them and restrict where they could see into the carcass so that they could only see essentially a little bit of the back. In many cases, couldn't see inside the carcass, where often you'll see fecal contamination, therefore, of course, could not write up noncompliance reports about fecal contamination. Also, apart from the affidavits, also a report from the USDA's own Inspector General raising some concerns about hemp, said, among other things, under hemp, plants have new flexibility so that they can limit oversight by simply reducing the number of critical control points, places where essentially inspectors can write up noncompliance reports identified in their plan. So another way in which whistleblowing can be nipped in the bud is simply by moving the control points where inspection reports might be written up around as essentially decreed by the plants themselves. And perhaps most fundamentally, hemp and MPIS, of course, dramatically reduces the role of inspectors themselves, in many cases replacing them with company employees who obviously are even less well-positioned in terms of legal protections, in terms of to whom they owe their paycheck, even less well-positioned to potentially blow the whistle. Finally, one other thing, dovetailing off of what we just heard about retaliation, there is, of course, also when the whistle is actually blown, retaliation itself. And prior to that, just knowing that retaliation is a possibility itself, of course, can have a very substantial chilling effect. And one way in which this chilling effect can be sort of constantly hung over the head of inspectors who might be tempted to blow the whistle is, of course, through intimidation, right? There are lots of informal ways to warn people before someone blows the whistle, before it gets to the point of formal retaliation. You know, as we've heard and as we'll hear about throughout the day, lots of forms of this informal retaliation, but I saw something in my research that made me realize that this is really not a new story. The pervasiveness of informal intimidation. And so, among other things, I found in 1991, the Atlanta Journal and Constitution did a really phenomenal series on problems in the USDA poultry inspection system and retaliation and intimidation against poultry inspectors. So they did a survey. They interviewed 80 federal poultry inspectors at 24 plants nationwide in 1991. 60 inspectors at the time reported that, quote, the department does not back them when they try to stop or slow the lines, unquote, to scrutinize carcasses that appear problematic. 45 inspectors told interviewers that, quote, they are routinely cursed, rebuked, and harassed by company officials or by their own government supervisors, unquote, when they try to take such action. So these are just examples of things short of formal retaliation that can keep whistleblowing from happening in the first place.
Well, and Alexis, before we just move on, I'm curious, you know, so Heidi's presenting this as a continual problem, but I'm curious how you've seen the current environment impact things. So, you know, I think Heidi points to the potential for deregulation, which is certainly a favorite of the current administration, to be problematic. We talked a little bit about the issues of immigration and documented status. You know, obviously we also have the Me Too movement, and that could be potentially empowering. You could also imagine that companies are being more aggressive to keep people quiet at the moment, to be out of the headlines. And so how are you seeing that play out?
You know, I haven't seen a significant change. Coming forward. Pressures are, since I deal with particularly folks in the private industry, you know, I'm going to revise that. I would actually say that people are aware that companies feel that their companies feel that there is less law enforcement and regulation going on right now. And so, you know, what I hear from my clients is, you know, things that I may have pushed 5 years ago that they would have acted on because instead I'm getting pushback and retaliation and subsequently when drop termination. So I do think that makes a difference in the private sector. And it also, you know, quite frankly, raises concerns government, that the government will take action. I certainly have had clients, we had a client who brought a very serious issue about contaminated food that was for vulnerable populations and brought it to the FDA, and they didn't really action, and that certainly empowered the employer to take action against our clients. So I do think that the current emphasis on deregulation, particularly roles of safety gatekeeping, affects whistleblowers because they know they're not going to have.
I'll just add one thing to that. If you actually want to get some action on your issue, often it just won't work for you to go to one place. I think a lot of the agencies now do not have adequate resources, and they really don't have any will in order to do their jobs, whether it's the FDA or the SEC. They're very weak. I think, you might start at the FDA, but don't be surprised if they're not willing to act. So you want to look at other options. You might want to go to the House Oversight Committee. They are very good. They certainly have a lot that they're working on. But let them know that the FDA is asleep at the wheel and get them to act. You might want to go to the media. There are various options. But what I've learned is that the place that's supposed to act often will not. So you want to look into other options. I don't know. You want to add to that, Paul?
Can I jump in real quick? I totally agree with Jason. It's very frustrating as sometimes, as we've seen particularly with Me Too, but if you look at the whistleblowing, the media is one of the best outlets for actually getting action, and that's where employees have the least action. And so, it's a double-edged sword. So the House now and the Senate, you do have protections speaking to the legislator, and that can be on the state level. So it is picking the right forum for how to get at.
Well, let me bring Paul in here, actually, because I think he'll have a perspective on the role of the media. Paul, in particular, as I mentioned earlier, works with anonymous speakers on the internet. And so I think, can you talk a little bit more about that and what the risks are and how you can use the media and what your potential vulnerability is, too?
Yeah, so my specialty for the last 20 years has been dealing with the use of civil litigation and the threats of civil litigation to suppress criticism of businesses. And whistleblowers are certainly a part of that. So you have to worry about being sued. You say what you say, and you say it's true, but the company, and my specialty is dealing with private power, not government power, the company says, no, what you said about us was false. And the claim is one for defamation or a claim for interference with business or the other kinds of pseudo-defamation torts that have to meet the standards of defamation under the First Amendment, assuming that the tort claim turns on falsity and damage to reputation or damage to business. Then, of course, you have the problem of disclosure of confidential information, which I gather Jason will be talking about more. Those cases are much harder to defend. And you have the problem not only of actual litigation, but threats of litigation and the sensible ways to respond to threats of litigation. And many whistleblowers want to do what they do, make their points anonymously or pseudonymously. And there are a lot of good reasons for that. They want to protect themselves against being sued for defamation or threatened with a suit. They worry about economic retaliation and social retaliation because truthful speech about a company can often lead to a plant closing. And people worry about the effects on their fellow employees, and they worry about being sent to Coventry and being ostracized in the community. They worry about the social consequences of being a snitch, which is a strong pressure against whistleblowing. So you have to worry about subpoenas to identify speakers, the bringing of litigation in order to get access to the subpoena power. And finally, the final thing one can think about doing is using, in addition to going to the press, and various ways you can protect yourself when you go to the press, the press is an intermediary, but sometimes you can speak more directly by using social media platforms. But there are, I think, increasing pressures against social media platforms using, being amenable to anonymous use. That I guess I'll talk about later.
Well, so, we're going to just suppress you for another couple of minutes by having Jason talk about non-disclosure agreements, because I think that's the last part of this kind of notion of the regulatory system and social pressures and then legal pressures through litigation being used to kind of squelch speech, and non-disclosure agreements are kind of a contractual form of that I think people particularly worry about. So.
Well, I've had a lot of cases, my client blew the whistle on a clear violation, and the employer then got rid of my client. The employer at that point had a few options. When I came in and I said, I'm going to bring a lawsuit, they could say, they obviously would be able to do the honorable thing and say, we screwed up, we regret this, and we will make your client whole. That almost never happens. Instead, they go on the offense and say, we didn't do anything wrong, we're going to sue the hell out of your client and show your client was not honest. It's not enough that my client's out of work. They now have to bring all these lawsuits against my client. Usually the claim is, when you show up at a job, right, you get handed a huge, huge employee handbook and a lot of paperwork. Nobody looks at that, right? They're just happy to execute it so they can start their job. Usually in that big stack is an NDA, and it's very broad. It'll often say, anything you learn in this job that's non-public information, you have an obligation to keep completely confidential for the rest of your life, and if you don't, we're going to sue the hell out of you, and you're going to pay all of our legal fees. And when I get clients and I ask them, do you have an NDA? They don't even recall what they have. But what will often happen is my clients don't know the law, and they hold on to some evidence on their way out of a clear violation, and they use that in their lawsuit, or they hand it over to the government. As I'll get into very soon, it's not happening as often as it used to, because I'm happy to say that there are certain agencies in the government that have gotten very, very active on this, including the Office of the Whistleblower at the SEC. But if I go back to about 08, 09, when I was at an earlier FIC conference, I was having to deal with these lawsuits all of the time. I would bring my client's claim, but then they would sue the hell out of my client again and again. And these were meritless claims, no harm, by the way. There was one where they put 8 lawyers at a large firm against us. My client was working a contractor for the Department of Defense. They had lied to the US government. And they put 8 lawyers on all these claims against my client. And I've got their key witness under oath. And I say, how has the entity been harmed? They can point to anything. This is just a way to make it very hard for my clients to pursue their claims, to get my clients to give up on their claims. And there also is a huge, huge edge they can have, right? It's a chance for them to go on the offense, because what do? They move for a preliminary injunction, and they try to get a hold of my client's hard drive, and then they do an examination of it and say, look at what this person held on to, and it really is an opportunity for them to go on the offense. So the issue is, what can we do? And what I've learned to do is I then go on the offense. So if I get a letter from the other side saying, your client has an NDA, we're going to sue them, I might move to get an injunction to have the court declare the NDA as invalid and to enjoin that entity from being able to force that NDA. I won't go into the anti-SLAPP laws. I'll leave that up to Paul. Those are very good. If you're in a state that has an anti-SLAPP law, I would bring a claim up under that law early, in part because you can get all of the legal fees, which they might be very concerned about. But one of the things I do if I bring a motion for a preliminary injunction is I would get some affidavits from other employees to confirm that they're not willing to blow the whistle because the claim that was brought against my client. The other thing I'll do when an employer has brought a meritless claim against my client is I bring a new claim saying that that lawsuit itself is an adverse action. It's an act of retaliation because it's meant to stop my client from blowing the whistle and to stop other employees. And again, one of the reasons I would do that, and I would write something up to the employer, is say, okay, you brought this meritless lawsuit against my client. I just wanted you to know that all of the hours I spend having to deal with this BS lawsuit where you haven't been harmed at all, you will have to ultimately pay that. So I don't want to go into too much about the law, but I am very happy to say that what we've seen over the past few years is that a lot of agencies, including the SEC, have made it clear that it is unlawful for an employer to try to stop someone from providing evidence of a violation of that agency. And if you have an employer that's gotten any money out of the U.S. government, there's a provision now that goes in all of the government contracts that prohibits any government contractor from spending money to prevent an employee from being able to blow the whistle. So when those lawsuits are brought, I think there are very good ways you can stop them. I would say, even if I get a letter from the other side where they say we're planning to sue your client, that in itself is an adverse action, and there's very good law on it. But it's very important that you act early, that you put the other side on the spot, because when you speak truth to power, I find that power often has a lot of money and a lot of lawyers, and they will bring these very meritless lawsuits, and it can get ugly. And actually, Louis Clark said something this morning that brought back some ugly memories, which they go after not only the whistleblower, but the whistleblower lawyer, like all kinds of BS arguments. You helped your clients remove our documents, so we're going to bring a lawsuit against you. We're going to go to the bar against you. I've had to deal with a lot of that nonsense. I still have my law license. But if you're going to go into this area of law, you really have to be prepared for that nonsense. And when it happens, you really have to be willing to go on the offense. I could go on and on about the law for hours. I won't. But if you want to get more law on this issue, I'll be happy to provide it to you. Sorry, the one last thing I would say is, in spite of all the arguments I've made that our clients do have a right under the law to report a clear violation of law to an agency of the government or the FBI or whatnot, it is a good idea, as I've learned the hard way, when you work on these cases, know early on what your client has, how they got it. If they stole something, that could be a problem. If they made a recording without the consent of the other party in a state that requires two-party consent, that is a problem. I think you really have to know, what does your client have? How did they get it? If your client is planning to hold on to documents to blow the whistle, that's one thing. But if they're planning to take it in order to make money on it or to use it in another job, that's a whole other issue, and that is a big problem. So you do want to look at the other side also and be very, very careful about it.
Well, and I think there are two components of this. And I want to bring Paul in a second about anti-SLAPP, but before we get there, so Alexis, I guess I'm curious to hear more about your thoughts about it. So we've given a kind of depressing presentation of all the risks and, and all the reasons people might not want to come forward, but picking up on Jason's point about kind of what we can do as lawyers to help defend whistleblowers. And we have got a question from the audience. I am reading these as they come in. I'm just trying to figure out how to work them in. So we got a question from the audience about, would you ever make the recommendation that someone not blow the whistle and be a plaintiff, or and kind of expose themselves, but rather leak information? Are there times where you kind of think that's appropriate, or do you think there are enough protections out there? And how would you kind of help people balance that from being a public face versus a private back room type of person? Yeah.
All right. So the question of, would I ever recommend someone not pursue their legal claims, but rather leak it or to the government? So I'm a lawyer. I'm conservative in true sense.
Cautious.
how lawyers are, which is seeing the bad and the good. And I come from it from an angle of there are often laws out there that, while not perfect, can protect. The challenge with doing something is often they can figure out who it is, but then they have the defense of, well, we didn't know it was that person, so you can't make a retaliation claim. You can't show what we call causation, right? That this flowed from the act, because that was just anonymous 101. Of course, they know it was the whistleblower because it's a really specific, powerful truth-telling is specific truth-telling, right? Is, you know, the more specific information you provide, the more it's, you know, the wrongdoers have a hard time refuting it. So, in my opinion, that is a very dangerous path. For a variety of reasons, some people may take that path, and if I advise clients that it's safer when it's the government also. You know, right now with Me Too, there's a lot of discussion, reporters about how frustrated they are about lawyers who, you know, advise people to, you know, not go public, journalists, but fundamentally you are taking on a lot of risk. And I have sat with clients and reporters and, you know, gone through all that, and we work a lot with reporters, and there's reporters to trust and whatnot, and sometimes it's the right decision, but it is a risk like all whistleblowing, and sometimes it's a risk worth taking both personally and broadly. We have, you know, with the advent of the Me Too movement and the focus on NDAs, which I think is very beneficial, not just for sexual harassment, but seize the moment and make the NDA issue broader than just sexual harassment. We filed a lawsuit in DC against both, it was a sexual harassment and retaliation lawsuit, but we did a preliminary injunction, extremely broad NDA, and we made the argument that it was chilling. It chilled other witnesses, it chilled people coming forward, because any layperson reading the NDA would see it as they couldn't speak to it. And unfortunately, well, fortunately for our client, the matter resolved, and it actually resolved, and this can be public, in a revision of the NDA. Unfortunately, it didn't create good law because it wasn't before the judge could do anything. But I do think that this is a moment in time when the public conscience is really outraged about the power of these NDAs, that we could seize it to, particularly when it's a broad NDA, to make good law, to make good points, to bring, you know, the media to see that this isn't just sexual harassment, it's stopping truth-telling in real other areas that society needs.
Well, and Paul, so someone had written a question. SLAPP laws are strategic lawsuits. SLAPPs are strategic lawsuits against public participation. They're what are known as an attempt to silence people from engaging in matters of public concern. And one of the things Paul specializes in is what are known as using anti-SLAPP laws, or working against those laws. And, you know, I'm curious, Paul, for you to talk a little bit about kind of both those laws and how they can be used to take kind of an advantage and take control. And then we've also got a question here about what responsibility the media has if they get information. You know, if they get information from a whistleblower, you know, what obligations do they have not to disclose? What can they do freely without any concern? You know, if you're a reporter, what worries do you have? So can you talk about a little bit about both of those issues?
So I'll start with the reporter. You know, you have a story that you want to get out, and a reporter, a press entity may be, excuse me, a way of getting that story out. But if what you need is confidentiality, you need to be very upfront with the reporter and indicate that you're not willing to speak without unless you're going to be treated as a confidential source. I mean, real journalists are going to be very protected. Just 2 weeks ago, I was at a session for defending journalists who are faced with threats over their coverage of matters that are of concern to the government and to private parties. And it was clear to me that real reporters are very concerned about protecting their sources. If they've promised confidentiality, they won't always do it. And that's just a choice that you make in getting your story out. If you're going to go forward, whether you're going to say, I'm only going to talk to you if you can treat me as a confidential source.
But what concerns, if you're the reporter, what concerns do you have in that circumstance? If you're the reporter, do they?
Well, you worry about being held in contempt and going to whether you're going to have to choose between facing daily fines and going to jail to protect your source. You have to worry about criminal prosecution if it's a source who's telling you things in the national security context. And there are reporters and media entities that are willing to stand behind their people, and there are reporters who are weaker. I don't think they have unless they they promise confidentiality. If there's a promise of confidentiality, that's actually an enforceable contract. But they don't have any obligation to take your story and promise you confidentiality. That's a choice that they make.
And both for reporters and for individuals, how have you seen the anti-SLAPP laws been useful? How have you seen them?
So I want to put the anti-SLAPP law, forgive me, but I want to put it in a broader context. The problem for the person who wants to speak the truth to power is how to finance their legal defense. And anti-SLAPP laws are one way of financing and providing a legal defense, but it's only one part of a bigger puzzle.
And can you just, so for those of you who aren't familiar, can you explain how they do that?
So I'm going to get to that, but I'm going to talk about something else first. Forgive me. If you're able to talk to a client before they've gone public, there are various things you can suggest to them. First of all, you can suggest to them to be careful about the way they characterize what they're talking about, to take advantage of the fact that a defamation plaintiff has to prove that false factual statements were made, and therefore to make sure that whatever you say is factually true and documentably true. That if you express opinions, you make clear that they're opinions based on documentable facts, because that comes to bear in the course of filing an anti-SLAPP motion and defending against defamation litigation. It's tempting to use strong words like criminal, and in theory, hyperbole is more protected when it's sort of strong language, but it's also likely to arouse greater hostility, and many judges don't like it, and they'll find a way to stick you. Another thing you can suggest to clients who are worried about facing litigation is to get insurance before they speak out. You can, in fact, get libel insurance in a homeowner's policy and in a renter's policy for only a few $100s a year by getting comprehensive coverage or an umbrella policy. And a lawyer who is talking to a client who is thinking of blowing the whistle and worried about the risks of litigation, I think certainly you face malpractice if you don't ask your client who comes in with a defamation claim, do you have libel insurance? But you can suggest getting libel insurance before you speak out. The clauses run state by state, but it's definitely something. I carry libel insurance. I'm a loudmouth. I think I know how to be a loudmouth without getting sued. But it's nice to know that if I do get sued for being a loudmouth in my community, as opposed to a loudmouth in my profession when presumably public citizen will defend me, that I have insurance coverage. It's a great kind of peace of mind. So now SLAPP suits. SLAPP laws are another way of financing the defense of lawsuits when you speak truth to power. It's very hard, in my experience, to get pro bono lawyers to defend libel cases. They're difficult cases, they're long cases, they're very fact heavy, and lawyers don't like to make pro bono commitments for these cases. There are some very good libel firms in this town who occasionally take pro bono cases. It's really hard, and I try to deliver people to those firms. It's really hard to get them to take the cases. You can sometimes get pro bono representation On the libel side of a case, if you have a damages claim that you yourself can bring, and then you wrap the defamation case into the affirmative case that you can bring against the person who you're worried about suing you. But anti-SLAPP laws are a piece of the puzzle. So what an anti-SLAPP law does, and there are about 30 states that have anti-SLAPP laws, only half of them are strong anti-SLAPP laws that do what I'm about to describe. They require the plaintiff, when you make a statement, either to a government agency or in some cases about a matter that a government agency is considering with the intent to influence the government agency or public opinion about a matter that's under legislative or administrative consideration, or speaking generally about a matter of public concern. That's the broadest anti-SLAPP laws. When you're within that area, you can bring an anti-SLAPP motion early on in the case that puts the plaintiff to the burden of showing that they have a tenable basis for the litigation, that they can show that what you said is false, that they can show that you spoke either with actual malice if you're speaking about a public figure, or at least negligently if you're not speaking about a public figure. In some jurisdictions, you have to show real injury, damages, and if the plaintiff can't make that showing, the suit is dismissed at the outset, and your lawyer, the one who brought the anti-SLAPP motion, gets an award of attorney fees. So for example, in California and some other states that have good anti-SLAPP laws, you actually have coteries of the bar, much as you have people who will bring civil rights suits, who developed a civil rights practice in the hope of getting awards of attorney fees under the civil rights law. You actually have a bar that specializes in anti-SLAPP defense. And that is a way of financing these kinds of litigation. The bad part about these laws is, first of all, they're only in certain jurisdictions. So the plaintiff may choose to sue you in a jurisdiction that doesn't have the anti-SLAPP law. And it's also currently unclear about whether, if they sue in federal court in diversity jurisdiction, whether this anti-SLAPP law applies. In DC, doesn't apply. Anywhere in the Fifth Circuit, it doesn't apply. In California on the West Coast, it does apply. I'm nervous about what the Supreme Court will do if it ever gets there.
Well, and just so you know, we're going to lose Paul in about 5 minutes. We will all do our best to play him on TV after we lose him, but that's just a scheduling conflict. Hopefully his libel insurance will cover us in those circumstances too. But I do think, so Paul's got a really interesting presentation of kind of the public civil system. And Jason and Heidi, both of you have done work in the government system. Heidi, through your research, and Jason from working at the Office of Special Counsel. And so can you talk a little bit about, for government employees, how that system works, what the Office of Special Counsel does, what it doesn't do potentially, and I guess probably start with Jason and, your work there, and talk a little bit about that system?
Yeah, I'll try to do this quickly. The Office of Special Counsel is not the one that's part of the Department of Justice that was in the news. Instead, this is an independent agency that was created after Watergate. It was created as part of the CSRA in 1978, which is about when you began to work in this area, Louis. And it's a great agency. It's a small agency. It's an independent agency. Unlike almost every other agency head, the special counsel cannot just get removed by the president at will. If that were to happen, I'm sure that the current special counsel would not be there anymore. What they're able to do is help people who blow the whistle. They can both order other agencies to open up an investigation of an issue and then report back to the special counsel, who can then go to the whistleblower, get their input, and then a report is provided to people on the Hill, the White House. It's put online. But the main thing they do is help protect whistleblowers who've been victims of retaliation. And it's what's known as a prohibited personnel practice. Not only people who blow the whistle on a violation of law, rule, or regulation, but people who've been the victim of retaliation because they had helped out some other whistleblower. They had been a witness before the MSPB, before the EOC. They blew the whistle to hell. I'm happy to say that under the WPA, which, by the way, we probably would not have if not for the very, very hard work of the Government Accountability Project back in 1989. That's one of the few laws where if you blow the whistle to the media, you are clearly protected, but you want to be very, very careful that what you blow the whistle on, there's no prohibition on you providing that information. So obviously, if you're getting into classified information, you can't blow the whistle on. But if you have a prohibited personnel practice complaint, you can bring that to OSC. They can perform an investigation. They conclude there's a violation. They can go to their agency to get you make whole relief, and if not, they can go to the MSPB. One of the things they can do early on is they can get a stay, which is kind of like a preliminary injunction. So if an agency took an act of retaliation, what the Office of Special Counsel do is they can go to that agency and say, we have reason to believe that that personnel action is a prohibited personnel practice. We want you to put it on hold. So if they're planning to remove your client because they blew the whistle, you might be able to get your client to stay in that role. One thing I just want to say about the OSC, it's a great agency, but has about 125 employees. There are about 1.8 million employees in the U.S. government who can bring a claim there. They are overwhelmed beyond belief. And I think that Dr. Oberg is in the back of the room. Is he here? Okay. So not to slam OSC, but Dr. Oberg, when he was working for the Department of Education, blew the whistle on student loan fraud. And everywhere he went, they said, no, we're not going to do anything about it. He went to the Office of Inspector General, went to Hill, whatnot. One of the places he went is the Office of Special Counsel. And they say, we don't really see anything here. I think he still has a copy of the letter where they said we're not going to do anything. Well, like a lot of other whistleblowers, he was not willing to look the other way. He pursued it forever, brought a case in the False Claims Act, pursued 11 years. As a result of his claim, he was able to allow the U.S. government to get back about $58 million. It might be a bit higher than that. The only reason I bring it up, it's not only because he's a hero of mine, but to say that, you know, the Office of Special Counsel is good. I felt we were able to help out a lot of whistleblowers, but it can take at least a year for them to perform a full investigation. It's very hard to get them to act. So, to my point earlier, if you have an urgent issue, if there's harm, for example, to the public, I'm not sure that that's the only place you want to go. You might want to go to the Hill. You might want to go to the media. You might want to bring your claim to the MSPB, not to get into too much detail, but when you've been at OSC for 120 days, if they don't act, you have the option to bring what's known as an IRA, which is an individual right of action, where you bring your claim at the MSPB, you get a hearing before an AJ, but we haven't even had a full MSPB now for, 3 years, so it can be on appeal forever.
Really not enough commissioners
Literally
Yeah.
zero right
members
now.
to have a quorum.
So, I mean, I could go on and on about how it works, so I don't want to bore people. The main point to know is that there is very good work at the OSC. They are an independent agency. They've been able to get a lot of relief on behalf of whistleblowers, but it's not the only other option out there. One thing you might want to do is to go to the Office of Inspector General of that agency. They might be able to act on an issue more quickly, and I find more and more it is really, really helpful to go to the Hill. So that's
I want to turn this over to Jaime. I want to make sure we get your acronyms out. So WPA stands for?
Whistleblower Protection Act, which was put in place in 1989 and was enhanced in 2012. And sorry, but what you have asked me just quickly reminded me of something. As a result of the 2012 Whistleblower Protection Enhancement Act, which again, we have primarily because of the hard work of the Government Accountability Project. I think they worked on that law for 9 years. There is an anti-gag provision in there which makes it a prohibited personnel practice for an agency to use an NDA to prevent an employee from blowing the whistle. So that's really key. If your client works at an agency and they try to stop him or her from blowing the whistle through an NDA, that's not valid. But for certain information, for example, if your client has classified information, you want to make sure that they blow the whistle the right way. When you have certain information that you're not allowed just to provide to anyone, there are places you can go. You can go to an OIG, you can go to OSC, you can go to the right people on the Hill, but it's very, very important to look at that issue closely and have a clear plan in place in order to make sure what you do is in compliance with the law.
Right, I think we see that with the current whistleblower complaint. Yeah, they talked a lot. There was a lot of initial, did this person do it the right way? Can we attack the whistleblower? And you can see the effect of just scrupulously following how to do that because we're able to, the whistleblower and the lawyers, protect the whistleblower by following.
Though what's unbelievable is that we learned this week that the president wanted to get rid of the IG. The IG of the IC did the right thing. The ODNI did not. He thought, oh, I'll go to the White House or the Department of Justice and see if it's okay with them if I go to the Hill. He should be removed. But the IG put it all on the line, and he would not back down, and he made sure that the issue was dealt with. And it is so key to have an independent Office of Special Counsel, to have an independent IG, and we have to work really hard to make sure that we can hold on to that.
Well,
It's
an IG is
absolutely key.
Inspector General, and I think, just so we keep our acronyms clear, and
Sorry.
and Heidi, yeah, so I do think, in terms of going back to the importance of the Office of Special Counsel, and I know your research really talks about this, and so can you just elaborate on that? And
Yeah, actually, if I could just for a moment sort of pick up where Jason and Alexis were going in terms of the Inspector General avenue
Great.
and the importance of sort of independent offices like Inspector General offices, as well as, Jason also mentioned the independence of the OSC. So just to pick up on the example, the extraordinarily timely example of the current whistleblower, I think both Jason and Alexis are absolutely right in terms of that. It's a very good example of how, in terms of protecting yourself as a whistleblower, sort of knowing the mechanisms to go through and the hoops to jump through, how crucial that is. That said, I think there are a number of cautionary tales that are still playing out here, right, with respect to the current whistleblower, one having to do with the efforts to retaliate against the whistleblower through potentially extra legal means, like we're seeing on the part of the president himself, the president's son, and others. But two other cautionary tales about the system. One is, so in a sense, although it's still playing out, the outcome thus far of this whistleblower complaint, in a sense, you could say it's an example of the system working beautifully, right? This person made a complaint, and eventually, and under the system through which they went, they reported to the Inspector General, to the IG, as they were supposed to. Everyone agrees. They crossed all the T's. They dotted all the I's. The IG went to the DNI, the Director of National Intelligence, as they were supposed to. The DNI, as Jason suggested, didn't do what he was supposed to do, which was immediately reported to the intelligence committees, but eventually word got to the intelligence committees, information came out, we're seeing what results. So in a sense, you could say this is an example of the system working really well. In a sense, though, I think it's an example of some limitations of the system. I mean, in a way, it's sort of happenstance that the information ended up coming out. As Jason suggested, the Director of National Intelligence did take steps that, instead of having the information go to the Congressional Intelligence Committees like it was supposed to could have led to it just being bottled up. Instead, the IG brought it to the Justice Department that, you know, essentially said, oh, no, 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 this isn't something that should go to the Inspector General. Could have ended there. Even if things had gone as they were supposed to, which is for the information to go to the intelligence committees, the reason the information goes to those committees instead of coming out publicly or being, you know, heard openly in Congress is because of the national security nature of the information. If things actually had gone smoothly and it had gone to the intelligence committees, it's possible it would have just been bottled up. You know, it would have been very routine. We wouldn't be talking about it now. So there are a lot of, you know, sort of a lot. It's very tricky in terms of figuring out how to make the system work, how to create channels, including the complicated internal channels that this particular national security whistleblower went through, how to make it work so that things run smoothly, so that in that case they protect national security, but so that things don't get bottled up. The other cautionary tale, of course, is about independence. And I do think, you know, so as Jason said, moving out of the current intelligence community whistleblower Ukraine situation and just going back to food whistleblowing, right? USDA whistleblowers. IGs, as Jason suggested, are really important in that context as well. The USDA has an inspector general. Indeed, I quoted earlier from something the inspector general of the USDA had said about hemp. They do indeed have some independence right now, in the sense that the president has to at least report the firing and any reasons for the firing if the president does terminate an IG. But that said, the president still does have the power to terminate IGs. There are people who have been fighting for 40 years, ever since the Inspector General's Act was passed in 1978, saying right now, even under the current protections, which are kind of a mixed bag for the Inspector General, that those protections go too far in protecting the IG. Most presidential administrations have been making the argument for over 40 years that the president shouldn't even have to report it to Congress when he terminates an inspector general, that this violates presidential power. So, you know, that's just, I don't want to go off on a tangent, but it is important to be aware that when we talk about creating independent offices like inspectors general, or offices with a modicum of independence, or the OSC, there have always been people, and this is true across administrations, fighting even those little bits of independence and saying that they violate presidential power, that the president has to have full power to fire whoever he wants for any reason without having to give explanations. So those are ever-present threats. Right now, again, don't want to go off on too much of a tangent, but I'll just throw in there without elaborating. Right now, there's actually a pending Supreme Court case about the question of how much independence can be given to these offices. Okay, but getting back finally to David's question, with respect to OSC and MSPB, you know, as Jason said, it's like all things in terms of whistleblower protections. It's a mixed bag. They do a lot of really wonderful things. There are the resource limitations Jason talked about. Perhaps most strikingly, right now there are 0 members of the MSPB. The MSPB has been without a single member, not just without a quorum, since March. I also want to just throw in, and I'll mention this quickly, but happy to elaborate if anyone wants follow-up. There's also the matter of where the First Amendment fits into all of this. As I think David had mentioned earlier, someone mentioned earlier, First Amendment isn't as active in this area as one might think. The most significant limitation probably in terms of First Amendment protections is that the Supreme Court in 2006 said that if so under the First Amendment, public employees as opposed to private employees, because public employees have the government as their employer, the First Amendment does apply to them. They do get some protections from being fired for speaking, but those protections are really limited, and probably the most important limitation is from a 2006 case called Garcetti v. Ceballos, where the Supreme Court basically said, if you speak in the course of doing your job, so if, for example, you're a poultry inspector, and your job is to spot shoddy poultry, and you spot it, and you speak out, and your boss says, you know, just give the company a break, stop complaining so much, and you're eventually fired for that, you're actually not protected because you were just doing your job. You do have protections under the Whistleblower Protection Enhancement Act of 2012, thanks in large part to GAP. And that's the happy part of the story. So from 1998 to 2012, you would not have had those protections, even under the WPA, because the Federal Circuit, U.S. Court of Appeals for the Federal Circuit, had interpreted the WPA, the Whistleblower Protection Act from 1989, had kind of almost inexplicably interpreted that act as not protecting you for on-the-job speech. WPEA, thanks in large part to Gap, in 2012 made clear that, okay, under the Whistleblower Protection Act, you actually are now protected. So you have that statutory protection. You don't have First Amendment protection. I guess that's a long way of saying it's a mixed bag, but there is hope, and a lot of the hope comes from groups like Gap and other groups with whom they've worked.
Well, so we need to wrap up in a couple minutes. I do want to say, we got a question about ag laws, and ag laws are actually an example in which the First Amendment has proven shockingly successful. So the ag laws come in a variety of flavors. Some prevent false speech to your employer, potentially not revealing that you want to do an investigation of a facility. Some prevent walking into and making a recording of an area where you don't need to be for your employment. And kind of universally, we've had some success using the First Amendment to fight back against those laws. And the courts have said that aspects of those laws or the entirety of the laws are unconstitutional. That's different than the on-the-job employee speech that Heidi was talking about, but it is a place that we've seen some rays of hope and actually making some really good law that protects the ability of both employees and also people who want to do undercover investigations. I think this is something Erica is going to talk a little bit about later on in the afternoon. But with an eye towards the hour, I guess I want to ask one last question here, which is we got a question, what policy changes would you like to see to better protect whistleblowers? And I think rather than make it abstract, is there anything that you think is really exciting that's on the, that's coming up? We probably won't see it in this administration. We probably won't see much in this administration, but that you think would either in the states or the federal level really be a boon towards whistleblowers, something that you want to see kind of get enacted. And we'll go down the panel, and that's kind of I think where we'll wrap up. Start with Heidi. I'm getting the signal.
Sure, I'll just mention this is something that I think is more potential than actuality at the moment, but I know that as of the last Congress, or maybe the last couple of Congresses, there's a new whistleblower protection caucus in Congress. This is an area, at least in the abstract, where there is a lot of bipartisan support when you talk about whistleblowing as a concept. Between the passages of the WPA in 2012, I think there is some hope for increasing the positive trajectory in federal protections.
I'm going to go crazy and suggest two ideas. One would just be a general federal whistleblower law that protected whistleblowers who raised reported issues for any violation of law, rule, regulation. And we have state wrongful God, why don't we have a federal one? So that, I don't even know if that's been proposed. And the other one would be the laws that have really effective preliminary reinstatement. I'm thinking of the mining. When employers are really threatened with an immediate reinstatement, real action. So, I mean, with SOX, Sarbanes-Oxley, OSHA and other OSHA ones, they can institute it, but OSHA is so overwhelmed. I'm just wondering if we really made that threat of reinstatement more meaningful and more immediate, what effect that would have for employers.
Saying really quickly, what you led with was what I was going to say, but what I'll add to Alexis, there is a bill written by the Government Accountability Project. It's like an omnibus bill to protect whistleblowers, because what we have now are all these laws where there's been a big scandal and there's some reform of an industry. What's worked so well for the Government Accountability Project is they can add an anti-retaliation provision. So we have these various islands of very narrow protection, and a lot of the burdens and the scope of these laws are very, very inconsistent. We need one broad law. There's one that's been revised by the Government Accountability Project. It's an incredibly long bill. It's a great bill. Hopefully it will become law at some point. The other thing is it is very, very important for all agencies to keep up this effort to try to block employers from using broad NDAs to bar people from blowing the whistle. I worked with Mr. Devine of the Government Accountability Project. We went to the Department of Labor back in 2016 and asked them to act on that. And we got some very, very helpful guidance out of the Department of Labor. That's just a really key issue to keep working on. But the last thing is, I think a lot of the laws we have in place actually are good. What we have at OSC, what we have with the IGs. The problem is these various agencies don't have any resources. I think there's been an effort to keep them weak. And I think if the US Congress were ever to be blue at some point, and it shouldn't have to be blue, by the way, there should be a bipartisan issue. But if it ever goes the other way, we really need to give these agencies the resources they need. Because, for example, under the QUITAM provisions of the False Claims Act, they're enhanced in '86, the US government has been able to recover $40 billion as a result of employees of US government contractors who blew the whistle. These laws can work very well, but we keep a lot of these agencies very weak so that they're not able to hold corporations to account. And that has to change.
And great, we are going to wrap up there. So let me say once again, thank you very much to GAP and the Food Integrity Campaign for having us. Thank you very much to the panel for your time, and we'll be around throughout the day to talk to you if you have any further questions. Thank you all.